We have Mr. Ramkumar Narinesingh with us via Zoom. And of course, he's an industrial relations consultant. And this morning, we're going to talk about fair and unfair dismissal. All right. And I want to say good morning to him. Hey, morning. Smile now, smile now, smile now. Unlike real people in the country have a job and we are alive. We have to say we have a job and we are alive, so it has something to smile for. Yeah?
Yeah, where's that one? Morning, Trinidad and Tobago.
Morning, man.
Yeah,
So,
that's right.
so we're dealing with fair and unfair dismissals, and what's the difference? That's part of the discussion. So, you go ahead and you start this off, because I know a lot of people, where dismissals are concerned, some people take it, they don't put up any fight, and because they just don't want to go to the court, they don't want to challenge in the court, they don't have the time for that, they probably don't have money to afford a lawyer, all these little things, the legal costs and so on and so forth. People tend to shy away from those things, but in truth and in fact, sometimes it's worth it. So let me hear where you're starting with this now.
Well, first off, Stefan, yeah, I agree with you. What we have happening in the country is, of course, people get dismissed. Different institutions, both state and private and public sector. People they don't know what to do. Now, I've gotten a lot of calls. The reason why I made a decision, I think, we need to talk about this, is I've gotten a lot of calls over the last couple of weeks from people who, one way or the other, their employment ended, and they were just lost. They did not know if it was right, if it was wrong. We have a system in this country, unfortunately, that does not really support a progressive approach to this issue. We have a trend of behavior where from time to time, you have institutions, businesses, organizations disposing of persons' employment statuses in a way that is, well, of course, it disregards their fundamental rights. And Stefan, what you have is an entire sector. Most of the time you hear that businesses, institutions are viewed in this way as merely being, adverse to the rights of employees. And that is actually not very true. Quite a number of employers in Trinidad and Tobago do follow the protocol. So first I want to clear up a myth. People misunderstand the difference between termination of employment and dismissal of employment. Most people think it's the same. They think it's interchangeable. So in all instances where an employment contract, terms and conditions of employment, the employment engagement ends, in all circumstances, it is a dismissal. However, some dismissals are termination of employment. So, in other words, your employment contract can be terminated, and it would be considered to be a dismissal. However, not all dismissals are in fact termination. So, termination of an employment contract comes about when an employer follows a disciplinary process, or is supposed to follow a disciplinary process, and as a result of the findings of the disciplinary process, the employee's employment contract, a decision is made to terminate, to end the contract. And then you have generally, well, that is considered dismissal, but that's just one form of dismissal. You have different forms of dismissal. You can be retrenched, which is a form of dismissal. So retrenchment, slipping my mind now, but you have other methods where an employment contract has come to an end, and it's considered dismissal. Now, I want to focus this morning really on termination of employment. That's why I'm not too concerned with all the other categories of dismissal today.
Yep.
Because we don't have enough. What you see quite happening a lot is that people get terminated, their employment contract. Sorry, people don't get terminated. That's also another mistake in statement that happens a lot. You hear people got terminated. And if you terminate someone, so it's not a termination of a person, but a termination of their employment status.
Right.
All right. So when you have where termination of employment contract is concerned, it can either be as a result of a progressive disciplinary process or a decisive disciplinary process. Now I'm going to pause here for a minute and I'm going to use an example here for the public to be able to connect with this a little more. Just imagine, Stefan, you're driving going down the road and they stop you, police stop you and they give you a ticket. They say to you that, well, you were found to be speeding 5 kilometers above the speed limit. And in the ticket, the allegation is made, of course, they have the findings, they have the proof via the radar gun, and they tell you that it's going to be life imprisonment. Just imagine that.
Right.
Is that something that would be acceptable?
No. For
You're going to pay for speeding, right? Now, what's the purpose of my example? The point about it is that the law is structured in a way where the punishment must equate the crime or the
Right.
punishment the wrongdoing, right?
Right.
Now, that principle applies in industrial law. So, for where an employee violates the terms and conditions of employment or is found to have violated, the employer does not have the right to decide that this warrants a termination of employment. What has to happen is the employer must reasonably consider the impact of that violation.
The violation of the employee,
and,
right? Yeah.
Yeah, the employer has to consider reasonably the impact of that violation found, and of course, take the necessary disciplinary action.
Right.
Now, people misunderstand what's the purpose of disciplinary action, right? Disciplinary action is supposed to be geared towards reformation.
Okay.
So you're supposed, let's say, Stefan, you're coming to work and you're always late. Now that's a progressive thing. You come to work late one day let's just think about it, Stefan, as equivalent to you getting a speeding ticket.
Mm-hmm.
1 day late and you get dismissed. That's crazy.
Yeah.
But if you're excessively late, right, what happens is that now the employer should warn you. There must be some form of progressive action where the employer has proof that he has given you the opportunity to reform, right? Now, of course, just like speeding, if you keep speeding, or you keep breaking the traffic laws, like we see I saw a guy, a taxi driver, lost his license for 6 months because he repeatedly broke the traffic laws.
Traffic law, yeah.
So that's a progressive thing. There's an ultimate sanction that will come. Thankfully, not put him in jail for life or anything. But coming back, the whole thing about it is that you can eventually lose a job if you show a consistent pattern of coming to work late.
Okay.
And there is an impact on the employer's business with you coming to work late over a period of time. And some people say, oh, it's just a few minutes. But just to put balance into perspective, imagine if every payday you get paid, the employer just reduce your pay by a few dollars. Every payday. They say to you,
most employees would find that unjust, but
right.
I understand where you're coming from. If you're reaching late on a consistent basis, and I deduct the equivalent of your tardiness in cash, then that's when the employee says, but this is unfair. But that's the whole thing. Employees, the employee-employer relationship, or the rules and all the little rules and terms of agreement. There's never really an understanding, particularly on the employee side. An employee will abuse certain aspects of their terms of agreement, and they will get a bly from the employer. Employers will give you a bly over and over and over, and then sometimes they get fed up and they say, listen, you're doing this way too much. We have a lot of people that with the clock in card, as you mentioned, in tardiness and coming to work late. There are many places of employment where Mendes, director, we were talking this yesterday, where people had a partner clocking the card for them. And they come in about a half an hour late. But when they come in late, the card already clocked because the partner clock it for them, you know. Um, these are things that people do, and they get away with it, and they're still employed.
Now, you mentioned two things there, Stefan. You said deduction and you said frustration. So I want to clear up two myths on that. One, people always say, well, I come late and the employer deducted my pay.
Right.
That is not a deduction. You see, for you to get a deduction, you would have had to earn the salary and it became yours, and then for some reason the other employer took it back. But once you come late, you didn't deliver on what you were committed to delivering, which is the 8 hours, and therefore you didn't earn 8 hours pay, so it wasn't yours to begin with. So really and truly, what the employer would be doing is paying you for the hours worked.
Okay.
And people are, oh, they cut my pay or they deduct my pay, but that's not true. You did not earn it, right? Now, now you talk about the next thing, the employer being frustrated. Now that in itself leads down the road, because principles of natural justice require that opportunity to be heard must be given.
Yeah.
So a man comes late, or there is probably a concern that somebody might be covering for somebody. And that's where, Stefan, some episodes ago, we spoke about employees who are working hard and their efforts are devalued by those who are compromising the terms and standards of the workplace.
Yeah.
So you have 5 employees, Stefan, coming to work on time, all the time. And they have one employee who consistently late, devaluing the efforts of the others, because they start to say, well, you know, why should I be on time? Now, the employer who's managing such a work environment, the responsibility is on the employer to address that situation, not get frustrated with it, but to address it in a salient and progressive manner. Now, most employers, Stefan, why are they frustrated? Because I'm juggling the bank, I'm juggling the forex demand, I'm juggling crime, my business place getting robbed every Saturday night, I can't sleep, juggling the worry about whether I will have business. And on top of that, now I have the people who are supposed to be working with me to make this business successful, some of them are working against me. So, and then on top of that, the employees who are meeting the terms and conditions, they now start to get frustrated. But what's interesting, Stefan, you never see an employee who is in the workplace challenging another employee, generally, on their wrongdoing. And you never see the employee going to the employer and say, hey, that man always late. What they generally do is they kind of stay in their lane. So, you know, like how we have crime in this country, and I always find it interesting. If the police shoot somebody and I want to be careful with this, sir, and I just want to say, in an instant, a criminal is shot, you always find that there's a hullabaloo on it for sure, and as you can see, there have been instances where that's justified.
Right.
There are situations where it doesn't seem to be justified, and you see a hullabaloo. But when you see a citizen being shot, or somebody, you don't see the public outcry against it in a real way. You don't see people come and say, hey, something, we need to support the police and protest against this. Yeah. So I was finding, and in the same concept, in the work environment, you find that, and it's very interesting. Now, I understand, I mean, we could talk about the psychological side of that, but I don't have the academic authority to do that. I just have experience in managing people. But staying in line with the work environment, employers, and this is my comment to you this morning, employers. You cannot allow your emotions to get in the way of managing these situations. And this is why it's very important to have some form of structure where somebody or some system is in place, for managing and monitoring the rules in your workplace, the standards in your workplace. So you don't, because it's difficult, Stefan, to separate the emotions. You see it all the time. I mean, you heard your caller just now. And about her comments, her views on what was posted online. It's everybody. There is a measure of emotion derived from our experiences that we walk around with.
Yeah.
Right. staying in line with this conversation on terms of termination, it's very important that employers separate progressive disciplinary action from decisive. And with our last few minutes, I want to clear up the separation. Decisive, Stefan, is when there is an incident in the workplace, and in the investigation of that incident, it is identified that the cause of that incident was because of an employee's willful, deliberate, or lack of attentiveness, the lack of attention,
Yeah.
and that in a loss to the business, or a compromise of the standards and ethics of the business, right? So how does that come about? Now, first off, before I go further, and the word incident is another buzzword that people misunderstand all the time. You ever hear somebody say, "Boy, we had an accident in the workplace, boy. That man, he was driving the forklift, and the forklift hit the top of the building,
Yeah.
and it was something." And they say, "Oh, he had an accident." You see, we make this because in civil law, just like when there's a vehicular accident in the road, they always call it an accident. You see, an accident is an occurrence where, because of lack of knowledge, or because a lack of knowledge, or a person, or something that went beyond the control of the person involved, something occurred, and it caused a loss or damage or injury. Right now, that's an accident. Incident is anything that happens.
Right.
And when something happens, please, Stefan, you're not supposed to label it an accident until you've done an investigation, because all accidents are incidents. Not all incidents are accidents.
Okay.
It's just like not all discontinuation of employment are dismissals, but not all. All terminations are dismissals. Not all dismissals are terminations.
Right.
You see these things all the time. It's got a little bit confusing. Right? Now, coming back to the incident, where you have an incident happening, you lost $65,000 in the workplace.
Yeah.
You had to do an investigation. Now, you might say, "Well, Stefan, you left me with the money. It's only place with the money, but you still have to do an investigation." Right. You know if somebody else took the money. You don't know what the circumstances was. You know if I got robbed. You don't know. You do you might feel you're definitive. Yes, I left you the money, and it's only you responsible. But you must give me the opportunity to be heard.
Right.
So it is an incident, right? And then, of course, we go through the investigation, and then if it is proven beyond reasonable doubt, or I have no reasonable explanation. Somebody said to me some years ago, they said, "Well, I lock up the vehicle. I sure I lock up the vehicle, but I don't know where the money went." I said, "Well, nobody reported seeing $65,000. It was more than that, so I just use that figure."
Right.
Go walking back, And in using the example about the forklift, when you do the investigation, you might find out that the guy driving the forklift, he saw the accountant walking by, and he just took a glance over and just to wave. And because of that temporary loss of attentiveness to what he was doing, he hit the building. Right. Or maybe he exceeded the rules of the height that the forklift is supposed to operate with. All these are little things that you see come up. So when you do an investigation, it is towards identifying the facts in order to determine whether to make an allegation to do a disciplinary hearing. Now,
we have about a minute, less than a minute.
Yeah. I see in that. So, in summary, what I would say is, for people in companies out there, I do not think that you understand, some of the businesses understand the magnitude of liability that they're facing when they do a termination of employment without following a process, or without having of managing the employee's violation in the workplace.
Right.
I don't think that, and yet you can literally bankrupt your business with industrial relations liability. Most of the time, Stefan, people get away because the employees, they didn't know, as you indicated at the start of the conversation, they didn't know, they didn't take action or whatever. But the truth is, people are becoming more and more aware. It is now a business in this country, Stefan, to take matters to the industrial court. It is a business, not just by unions. Make no mistake about it. Whilst the union is the only body that is given the authority in accordance with the Industrial Relations Act to go to the court, we are seeing a lot of legal practitioners, a lot of IR consultants who are now seeing it as a business, a thriving business. And that is because the employers are not putting the proper systems in place. So you allow to become exploited by this system now. And now you have IR practitioners and legal practitioners who are deliberately not giving the proper advice because it's a money-making business.
Yeah. I would imagine that because, yeah, well, I would imagine that because the amount of matters that backed up in the industrial court right now, a lot of them would have to do with, I mean, a lot of those matters would be wrongful dismissal and things of that nature. And people have the right to go and challenge being dismissed by the employer. I guess it's up to the industrial court to establish whether you were wrongfully dismissed or not, and then I mean, if that's the judgment, you could appeal. I would imagine there is an opportunity to appeal and all of that. But I think the best place to go to get justice in any event of wrongful dismissal is to challenge in the court. And I just think a lot of people let things slide. But I think now you're correct. I think more people. Because of the amount of information that is out there as opposed to way back when, although the system itself is a bit difficult to maneuver, but I think a lot more people are saying, listen, I'm going to challenge this. I think we live in a society that are willing to challenge things more now than they would have 10 or 15 years ago. And that... A
litigious society.
Yeah. So I'll tell you what, we out of time, we're 7 o'clock, but thanks a lot for joining us and giving us some information on that. And until next week, Thursday, man.
Of course.
Yep.